On November 21, 2021, officers with the West Covina Police Department attempted a routine traffic stop on a vehicle driven by Ronnie Parham in West Covina, California. After officers activated their emergency lights, Mr. Parham stopped the car a few seconds later, reaching his grandfather's house. Upon stopping, Mr. Parham exited the vehicle in a compliant manner with his hands raised. Despite his compliance, officers arrested him for felony evading, allegedly slamming him to the ground and inflicting severe facial and arm injuries through physical strikes. Officers subsequently transported Mr. Parham to a hospital where medical records noted he refused treatment, a point Mr. Parham disputed in deposition testimony, stating he was sleeping and was denied medical care before being booked into jail. Following a criminal trial in which a jury acquitted Mr. Parham of all charges, he filed a civil rights lawsuit in federal court alleging false arrest, excessive force, unlawful search and impoundment, malicious prosecution, and deliberate indifference to medical needs. The district court judge denied the officer's motion for summary judgment based on qualified immunity, ruling that genuine disputes of material fact existed that required resolution by a jury. The officers subsequently appealed the decision to the U.S. Court of Appeals for the Ninth Circuit, arguing that they had probable cause to arrest Mr. Parham for evading. The appeal was set for oral argument on November 21, 2025 at the Ninth Circuit Court of Appeals in Pasadena, California, before Judge Marcia Berzin, Judge Randy Smith, and Judge Eric Miller. The appellant officers were represented by attorney Scott Davenport, and Mr. Parham was represented by attorney Nishan Neal. Because the officers initiated the appeal, Mr. Davenport presented his oral argument first.
Good morning, Your Honor. May it please the Court. Scott Davenport and my partner Melissa Ballard for the appellants. I would like to reserve 2 minutes of my argument for rebuttal.
Just try and watch the clock.
I will. Thank you, Your Honor. On November 21st, 2021, exactly 4 years ago today, West Covina police officers were on patrol when they attempted to perform a routine traffic stop on a vehicle driven by appellee Ronnie Parham. Unbeknownst to the officers, Parham had suffered 4 felony convictions and been sentenced.
What's the relevance of that? Did they know it at the time? It was unbeknownst to them, so it's completely irrelevant.
I think it goes to his mind.
Wait, excuse me.
I'm sorry.
Did they know it at the time?
No, they did not.
All right.
I guess what we're trying to do is we're trying to make sure that we have jurisdiction over this appeal.
Absolutely.
Because if we have jurisdiction, it's limited as to whether your officers are entitled to immunity as a matter of law, assuming all factual disputes are resolved and all reasonable inferences are drawn in the plaintiff's favor. So we can't look at what facts your officers would allege, really, except as to what they allege that hasn't been contradicted by the plaintiff. But we have to look every time at what the plaintiff alleges and then apply the standard that applies in qualified immunity cases. And so I think that's why Judge Berzon's question was pretty important, because we're really looking at what did the plaintiff allege and how is the law such that even with the plaintiff's allegations, you would win.
Understood, Your Honor. Let's start it this way then.
I'm going to be fair. I looked at the dish cam, and I don't think it helps at all.
Understood. Let's go with what does help then. Let's talk about the non-force claims, and that would be the search, the detention, the malicious prosecution claim, because there's really 3 issues in this case. There are his excessive force claims, there's the non-force claims, and there's the deliberate indifference claims. Let's start with this middle one, the non-force claims. Hopefully I can get some wind at my sails at that point.
False arrest, you mean?
False arrest, malicious prosecution, illegal search, inventory search, those ones.
Well, the false arrest stands or falls with what happened during the incident that you can't see on the video, right?
No, not completely. It also has to do with the felony evading that happened before that.
The felony evading?
Yes, ma'am. What happened was the plaintiff, for his part, admitted that he saw lights behind him and didn't pull over. He admitted that he stopped and pulled away, and he admitted that the officers activated their sirens, and he still didn't pull over immediately.
Well, according to him, he didn't see anything until he turned into the last street, and then he pulled over, and then he decided he was going to go down the street to his grandfather's house and stop there, which is what he did.
That's right. He pulled over, and then he kept going, even though he knew they were behind him. He admitted to those
Certainly
facts.
didn't speed up. He certainly wasn't trying to flee. That was pretty obvious.
Your Honor, he admitted these facts. I don't know. And there is video of it with an admission and video. I'm not sure.
No, but you say, for example, in your brief that he sped away. Well, he didn't speed away. He went at the speed limit on a residential street. When there was no indication that he was fleeing.
I don't know what other indication there can be when you pull over from a police officer and then you pull away after 1 second. And we're looking at this from the perspective of the reasonable police officer on the scene. This is a man who, for whatever reason, did not stop, and then eventually did, and then after he stopped for a moment, he took off again. And then he eventually pulled over a second time. That's the backstory of what happened, and that's the basis. That's one of the bases for the arrest, separate and apart from the use of the force. And all of that happened before any force was ever used in this case. So those are undisputed facts. He doesn't dispute them. He admits them. So where are we? We have probable cause to arrest for the flight. So there can't be, by definition, malicious prosecution. There cannot be an illegal search. There can't.
Why not? I mean, because when you arrest someone in a vehicle, you can search the vehicle if they're still, able to grab something from the vehicle, which I don't think he was at this point, or if you're looking for evidence of the crime of arrest, right? But you're not going to find in the trunk evidence of failure to yield. So what is the basis for a search, even if the arrest is valid?
Inventory search under South Dakota versus Opperman.
But an inventory search is permissible when you're going to impound the vehicle, right?
Which they did.
And as I read Section 22651 of the Vehicle Code, you can impound the vehicle if it's like blocking traffic or somewhere dangerous, but this seems to have been a legal parking place on a residential street. So what's the basis for impoundment?
Impoundment was because it was incident to arrest. If the officers
But
would have left
that's not the criteria for impoundment.
If the officers would have left it there and something would have happened to it, then we'd be drawing a suit for failing to secure the vehicle.
Well, am I looking at the wrong statute? Because the statute, the provision of the Vehicle Code I mentioned, talks about when impoundment is appropriate and does not seem to cover the case where you're parked in a legal space, you're not blocking traffic or anything.
In front of your grandpa's house.
Your Honor, as far as we were concerned, the issue that was always briefed below is that this was a search incident to an arrest and an impoundment following the arrest. So,
But the district court seemed to disagree with you in that the district court said that it could go in either direction, whether he was evading arrest or whether he didn't, or whether he was resisting arrest or whether he didn't. Even the district court said there's two sides to this story, and given the side of the story that the plaintiff tells, I can't give you summary judgment.
that's where I think there's the fundamental problem here is I don't know how you can take plaintiff's admissions and look at that video and say that there's no evidence of evading. And I'm talking about proof beyond a reasonable doubt.
You're suggesting that we could look at that video and say that because he stopped once, but he thought I'll stop instead in front of my grandpa's place, that's evading?
Absolutely.
Mr. Davenport argued that the police officers were entitled to qualified immunity on Mr. Parham's non-force claims, contending that independent probable cause existed for felony evading under California Vehicle Code Section 2800.2. The defense maintained that the plaintiff's own admissions and dashcam footage established that he observed emergency lights and heard sirens. It pulled away after a brief stop and failed to yield immediately, opting instead to drive to his grandfather's residence. However, Judge Berzin dismissed the defense's attempt to cite the plaintiff's prior felony record, clarifying that facts unknown to the officers at the time of the stop are legally irrelevant to the Fourth Amendment analysis. Furthermore, the defense asserted that the search of the trunk was constitutional as an inventory search pursuant to a lawful impoundment under South Dakota versus Opperman. Nevertheless, Judge Miller questioned the statutory basis for impoundment under California Vehicle Code, Section 22,651, observing that the vehicle was legally parked on a residential street and posed no traffic hazard, while Judge Berzin emphasized that an arrest alone does not satisfy the legal criteria required to justify impounding a vehicle. Ultimately, the court indicated that the conflicting evidence regarding whether the plaintiff was actively evading arrest or merely seeking a safe location to yield creates a genuine dispute of material fact under Rule 56 of the Federal Rules of Civil Procedure, thereby precluding summary judgment on qualified immunity as a matter of law and requiring these factual discrepancies to be resolved by a jury at trial.
When the cop pulls you
That's
over,
your argument?
yes, sir. And before that as well. When a cop pulls you over, you don't get to decide, like, I'm going to wait and pull over
No, but
3
just
miles.
a minute,
from
this
there.
isn't like he's going to drive across town. In Idaho, and I'm not sure because it's a totally different situation here, it would not seem unreasonable if you were down the road from your place to stop there instead of stopping where you first stopped. I'm trying to figure out how the jury would say that is absolutely evading arrest.
And
If he had kept running, if he kept going, if he'd gone and if he tried to do other things, but just to pull down the street to his grandpa's place? I'm putting the facts in his stead, not in yours. I realize the officers may have a different story, but I'm just saying what he says.
Well, there's only one story here, which is that he admits that he did not pull over and that he failed to yield.
Oh, I see.
Is there any evidence in the record that an officer observing his behavior would have been aware that he was going to his grandfather's house?
No. No, that was an unexpressed subjective intent.
Is there any, and I don't know the answer to this, but is there a mens rea in failure to yield? Do you have to attend to evade arrest?
You know, as I sit here, I couldn't tell you whether that's a general intent or a
Well,
specific
well, if
intent.
you do, obviously he didn't. I mean, he pulled over.
Well, I don't know if that's true, Your Honor, because what he did do was he did not pull over, he did not yield, he intended to not
For
yield.
47 seconds.
I'm sorry?
47 seconds
47 seconds.
between when he stopped the first time and when he got to his grandfather's house.
Yes. Yes. And there was the initial evading
I
as
think,
well.
is this one of the things that went to that as to which there was a trial and he won?
Oh, and in the criminal context?
Yes.
Yeah, I believe so. I believe so.
Right. So
But
doesn't that demonstrate that a jury could find otherwise because the jury did find otherwise?
but we're not talking about proof beyond reasonable doubt. We're talking about probable cause. Did they have probable cause to arrest? Which is a much lower standard. You all know that. It triggers at a much lower rate, and that's all that the officers needed to justify the stop. I would like to talk a little bit about the deliberate indifference before we come back to this, because before we come back to the actual force where the meat is, I'm running out of time here. The undisputed facts show that he was transported to the hospital. The hospital documented that he refused treatment, and then he was taken back and booked. And the officers reasonably relied on that.
So he said, I'm looking at ER 59, his deposition. Question, did you tell anyone at the hospital that you did not want any medical treatment? Answer, no. So maybe if we look at the records, we would say, maybe he's lying. But isn't that a factual dispute?
It's not, because I think what we have here is we have a qualified immunity. There's no specific case law which says that the police officers could not rely on the medical reporting. And that's what they did.
Wait, do we know that they relied on the medical report?
I'm sorry, Your Honor?
Is there any evidence that they relied on the medical report as opposed to the fact that there later was a medical report?
There's been no allegation that it was a lie in the medical report.
Right,
No.
but I think the question is there any evidence that they had the report at the time? I mean, sometimes the report
The
gets
officers
written up.
indicated that they took him back after they documented that it was refused.
After who documented?
The medical staff. So the officers reasonably relied on the
But the
medical
officers
staff.
were there the whole time, right?
I'm sorry?
Weren't there officers with him?
I can't speak to that.
Where is that in the record that they said that they relied on
I was going
the
to say,
document?
where's that on the record?
I will get that for you
Okay.
in my intermeeting 1 minute here when we go back. But that's where there is no prior case authority talking about what the officers can and cannot rely on in terms of medical reporting. Once the
There's no question, however, that a government official cannot deny, delay, or intentionally interfere with medical treatment. That's absolute, right?
that's correct.
And you agree with that?
I agree with that.
And so if that's what we're looking at, which comes out of Sandoval, you think the very fact that the officers may have seen that the hospital wrote down that he denied treatment is enough?
Yes, sir.
Okay, I want
And-
to
and there-
understand your argument.
And there's no case law to the contrary. I asked to reserve 2 minutes. I'm at 2 minutes right now.
All right.
So I'm going to find you your case.
All right. Thank you very much.
Judge Smith questioned how an objective observer or jury could view Mr. Parham's decision to pull over near his grandfather's house as absolutely evading arrest, contrasting the short distance driven with high-speed flight across town in Idaho. Mr. Davenport disagreed with this characterization, contending that the record contains only one undisputed narrative. Mr. Parham admitted he failed to pull over immediately upon receiving police signals. Furthermore, defense counsel emphasized that the legal inquiry centers strictly on whether the officers possessed probable cause, which according to him was met when the driver failed to yield. Under District of Columbia versus Wesby 583, Judge Berzin expressed strong skepticism regarding the objective reasonableness of the officers' conclusions under the totality of the circumstances, highlighting from the record that a mere 47 seconds elapsed between the initial signal and Mr. Parham coming to a complete stop at his relative's residence. In probing the statutory elements under California law, the judge questioned whether a failure to yield charge requires a specific mens rea, noting that any such criminal intent was patently lacking given the brief duration and the driver's eventual compliance. Addressing the 14th Amendment medical care claims brought under 42 U.S.C. Section 1983, Mr. Davenport argued that the officers are entitled to qualified immunity because no clearly established binding precedent dictates that law enforcement cannot reasonably rely on medical staff documentation regarding an arrestee's treatment status. However, Judge Smith countered by reaffirming established Ninth Circuit precedent, which clearly establishes that a government official cannot deny, delay, or intentionally interfere with necessary medical treatment, questioning whether qualified immunity can apply if the officers actively interfered with Mr. Parham's care. The court pressed Mr. Davenport on the evidentiary support surrounding the hospital records. Judge Miller and Judge Berzin emphasized that Mr. Parham's deposition testimony directly contradicts the hospital's written report. Moreover, because the record lacked clear evidence demonstrating that the officers actually reviewed or relied upon the medical report prior to removing Mr. Parham and booking him into jail, the court noted that this factual conflict creates a genuine dispute of material fact regarding the officers' deliberate indifference. Mr. Davenport completed her argument, reserving the rest of his time for the rebuttal. With that, Mr. Neal had the opportunity to present his oral arguments.
Good morning, Nishan Neal. May it please the court, Nishan Neal on behalf of appellee Ronnie Parham. I believe the panel nailed the beginning part of this argument. This appeal centers on whether this court has jurisdiction to hear a challenge related to appellants being denied qualified immunity after violently beating a compliant Ronnie Parham. The district court actually made it very clear, looking at the video and the record, that it's reasonable in both directions for the plaintiff at the time, or the district court thinking it was Ronnie Parham, or the officers. And that's very important when it comes to the question of a denial of a qualified immunity. In regards to
I'm not sure that the district court's ruling is something that has to stand. They're doing the same thing we're doing, right? They're just saying, put all of the inferences in Parham's favor, assume all the factual disputes are resolved in Parham's favor. Are they entitled to qualified immunity? And the district court said, I looked at the video and I don't think they are. But you've got to respond to his argument. What about this idea of false arrest? He stops and then he goes. What are you going to do with that?
So the false arrest concern, it goes on to whether it's a probability. And I believe you may have asked earlier, the panel asked, was there probable cause? And the question is whether it is a mens rea requirement for intent to evade. And that's Vehicle Code 2800.1. And that's important because Ronnie Parham's testimony was he slowed down and he was nervous. He did not see the lights flash, and that's admitted was later on. And then he was nervous because because of his friend who also was beaten by the West Covina Police Department. So he wanted to make sure he was somewhere safe, which was only like a short drive, about 40 seconds to his home. And and it's very important to say that.
Yeah, I mean, so that, I think you're right. I mean, if credited, that negates intent, and evidently the jury believed it, and I guess that's why he was found not guilty. But on the question of probable cause, it's undisputed that they turn on the lights, he pulls over, stops very briefly, and then resumes driving for another 45 seconds or so. Is that right?
Yes, Your Honor.
And so the officer observing that, they have no idea why he's driving away. You don't think that just that behavior is enough to create at least probable cause that it might be because he has the intent to flee?
No, Your Honor, because after the slow pause, he did not speed up. He was very safely down a residential street. And as you see it, as you watch the video, immediately he stops and rolls down the windows. We can't hear any audio.
But isn't
and his hands are up.
I mean, by the time they arrested him, he had already stopped 45 seconds later down the street. So they would have had to have probable cause at that point to think that he was refusing to yield. And in fact, there he was yielding at that point. So, I mean, in other words, isn't the whole story relevant to whether he failed to yield, not simply what happened at the point that he stopped and then kept going? Because they didn't arrest him then, they arrested him later after he did stop.
Yes, Your Honor, the whole story matters, and that's the reason why it matters is because it's taking all of the circumstances into account. And it's important here is that I know that criminal standards are different, but a jury looked at this same evidence and said there was no crime that existed.
Well,
and that's important to say if it's reasonable.
I understand, but if you'd focus on probable cause, what is it the officers needed for the probable cause?
At this point, for the probable cause to arrest him for failure to yield was that he had to have intent to flee or elude the police.
And when did he get arrested for this?
After he got out the car and his hands up and stopped.
So after he got to his grandpa's place. So that's why Judge Berzon's question is pretty important. One can suggest that one doesn't have probable cause anywhere along the way, but it's where they have probable cause to issue these warrants. Isn't that what we're looking at?
When they arrested him.
Yes.
So when you're looking at the probable cause analysis, the statute is very important here, is that they had the lights switched over. It's the Rodney Parham states when he made the right, that's when he did that, that's when he slowed down. And then a few seconds later, he stopped. And that's not probable cause to say he was trying to evade with the intent to flee, because the video shows he's moving very slow, not going fast.
But also the video shows that he did stop before he was arrested, very, very shortly after the earlier thing.
It was a brief pause, yes.
Right. So what about the medical issue? Is there anything in the record that suggests that as opposed to Parham says that it was the police, it was the officers who told the hospital that he didn't want treatment. But is there anything to demonstrate that they relied on a hospital-generated note that the officers relied on a hospital-generated note that Parham didn't want treatment?
No, there's nothing in the record as it relates to the officers relying on that record. It's nothing. There was no testimony of a medical personnel that said this is what they wrote and they have this. It's very important to note that Rodney Parham says he was still in pain, the physical injuries were still there, and that he never received treatment. He was there for some long period of time and was never received treatment. And his facial injuries and his arm injury are very severe. So it's not something to say that it's his testimony that they interfered with him because he was not ready.
He was sleeping or something.
Huh?
He was sleeping.
He was sleeping. He was not refusing treatment. And so that's the point, is that the story could be believed either way, but on the qualified immunity analysis, it looks at the the account from the non-moving party. And here is Parham. Parham said he did not. The officers interfered with him, and it's up for the jury to make that decision on each case, because the law is very clear at the time of that if the officer was interfered with the medical treatment, that's a constitutional violation.
Well, and your colleague admitted to that. I guess the big deal was he was suggesting that because the hospital had said he refused treatment, it gave them enough reason to do what they had to do, and that's a different standard in that particular situation. I guess what you're arguing is that's just some evidence in his favor, that as far as you're concerned, Parham never denied treatment, period.
And that is correct. That is my argument. And there's nothing in the record to say that there was a testimony that says he actually did so. It's both parties saying, no, I didn't. They're disputing it. So it's a he said at this point. And it's in this case, when we're thinking about on appeal, the court saw it, and it was said it's two ways, and that's important.
Mr. Neal argued that the district court properly denied summary judgment on qualified immunity because genuine disputes of material fact persist regarding both the false arrest and medical interference claims. Addressing the bench's inquiries on probable cause, Mr. Neal maintained that the underlying offense, misdemeanor evading under California Vehicle Code, Section 2800.1, requires a specific mens rea demonstrating a willful intent to evade or flee law enforcement. Judge Miller questioned whether an officer observing a driver briefly pause and then drive away for merely 45 seconds possesses objective probable cause to suspect criminal evading. In response, Mr. Neal emphasized that under the Fourth Amendment Standard District of Columbia v. Wesby, 583 U.S., probable cause cannot be judged by isolated moments in a vacuum, but must be evaluated by assessing the totality of the circumstances from the perspective of an objectively reasonable officer. Contextualizing Mr. Parham's state of mind, Mr. Neal explained that Mr. Parham drove at a very slow speed down a residential street for 45 seconds to reach his grandfather's house. Because Mr. Parham never accelerated, maintained a low speed, and immediately surrendered upon stopping, Mr. Neal asserted that no reasonable officer could infer a willful intent to flee. Under Estelle v. Gamble, 429 U.S. 97, Mr. Neal contended regarding the deprivation of medical care that officer interference with necessary medical treatment for severe, obvious facial and arm injuries constitutes a clearly established constitutional violation. Mr. Neal emphasized that Mr. Parham was sleeping and incapacitated, not refusing treatment, and that no hospital personnel testified to substantiate the officer's claim that Parham declined care.
And then I want to also touch on, just to make sure we're, as it relates to the probable cause and fault, it's very important, I believe, that claims goes with the inventory search. Even I want to make sure that the court's aware that defendants did not bring that issue up to the district court. So the concern about whether this was an inventory search has been waived by that party. And that's very important, that they have to be respectful of the information that they did so. And this is not.
What was the position at that point? Was that it was a search incident to arrest? Was that there?
That was the only thing that was there. And they did not say it was towards an inventory search as it relates to it. And even if the court was to do so, there was a disputed fact there, because the statute has a limited exception to impound the car and do the search, and it's under the caretaking function. Yes, that's true that left there would be a potential cause, but that's not the case in this fact. The fact shows his sister, Mr. Parham's sister, was outside and could have taken that car. So the concerns that the officers had about the community caretaking is not.
But also, if you look at the video, they were searching the car. They weren't caring for it. They looked all over the car for something or other. And that's not what you ordinarily do in an inventory search. They weren't just trying to figure out what was in the car to record it. They were looking for something.
And also want to make a note is that if the court was ever to consider the excessive force concern, that some of the Graham analysis is also important, that appellants actually waived the argument about whether the severity of the crime was at issue. And that's important because as you go through the Graham analysis and whether this thing is, if they waived it, they can't bring it up on appeal. So this court has to consider that the severity of the crime was low, so the concern of a felony evading is not something that could be considered, as well as the balancing test as it relates to the immediate threat the officers faced. It's very important there because looking at the facts, you saw him not resisting, and so the court's been very clear that non-trivial force, such as kicking and to the head And punching to the head is considered intermediate force, and you cannot use that. And that's been as clear as day from the Ninth Circuit since 2001. So the officers knew that they weren't able to do that. And so that's important for the court's analysis if it was to see the excessive force. But if there's no further questions for the panel.
Can I just have maybe one or two more questions on the false arrest question? Right, so to overcome qualified immunity, you need to show not only that there wasn't probable cause, but that no reasonable officer on these facts could have thought that there was probable cause, right?
That's correct.
So, I mean, is there case law that you can point us to that would say that, coming to a stop and then driving away for 45 seconds and then coming to a second stop, that's just, categorically, that can't be probable cause of fleeing?
I believe the law will look for it as McKenzie versus Lamb as one of the cases of the Ninth Circuit that talked about that, and the district court cited. And it's important to say that when you look at it, it's actually the video going back and forth to both points. I think that lets know at the time of the arrest there was no probable cause for that evading, because here it was about a ticket. You're not arresting for a ticket in that same vein. And he showed him compliant assailant. His hands were out. He put his hand in the video, which we can clearly see that he was compliant. And that's important for that analysis.
Mr. Neal addresses whether the search of Mr. Parham's vehicle could be legally justified under the community caretaking exception. This inquiry goes to the issue of whether officers had a valid administrative reason to impound and inventory the vehicle, or whether the search violated the Fourth Amendment. Under Miranda v. City of Cornelius 429, the community caretaking doctrine permits law enforcement to impound a vehicle and perform an administrative inventory search to protect public safety or secure property. Colorado v. Bertine 479 establishes that this exception is strictly limited and cannot be used as a pretext for a general criminal investigation. Here, Mr. Neal points out that Mr. Parham's sister was present at the scene and fully capable of taking custody of the car. Because a responsible party was available to secure the vehicle, there was no legitimate administrative need for the officers to impound or inventory it. Furthermore, Judge Berzin highlights that the video evidence shows officers actively looking all over the car, quote-unquote, for something or other, rather than conducting a routine property inventory, demonstrating that the search was investigative rather than administrative. Mr. Neal evaluates the officers' use of force under the three-factor balancing test established by the Supreme Court in Graham v. Connor. Those factors are: 1. The severity of the crime at issue. 2. Whether the suspect poses an immediate threat to the safety of the officers or others. 3. Whether the suspect is actively resisting arrest or attempting to evade arrest by flight. Mr. Neal emphasizes that because any argument regarding felony evasion was waived by the defense, the severity of the underlying crime must be evaluated as a minor traffic offense. Under Headwaters Forest Defense v. County of Humboldt 276, physical strikes such as kicking and punching an individual in the head constitute an intermediate, non-trivial force. Controlling Ninth Circuit case law clearly establishes that officers violate the Fourth Amendment when they deploy intermediate physical force against a compliant, non-resisting suspect. Judge Miller questions whether existing precedent provides sufficient clarity regarding whether driving for 45 seconds to reach a second stop negates probable cause for felony, fleeing, or evading. This inquiry goes to the issue of whether the law was quote-unquote clearly established for the purpose of qualified immunity on the false arrest claim. The so-called clearly established prong of qualified immunity asks whether, at the time of the arrest, existing case law put the lawfulness of the officer's conduct beyond debate, such that every reasonable officer would have understood that arresting the suspect under those specific circumstances was unlawful. Here, Judge Miller is probing whether the factual timeline, stopping briefly, driving for 45 seconds, and coming to a final stop, left room for reasonable disagreement among officers about whether probable cause existed. In response, counsel points to Ninth Circuit precedent in McKenzie v. Lamb, arguing that no reasonable officer could believe probable cause existed for felony evading when a driver briefly moves to a safe area for a minor traffic ticket and displays immediate, visible compliance upon stopping. After Mr. Neal finished his arguments, Mr. Davenport had the opportunity to do her rebuttal.
I'll keep it brief since I'm limited to 2 minutes, Your
I
Honors.
want to ask a question. You spent a lot of time in your brief arguing about Scott and the notion that the video was somehow informative. I gather you're giving up on that.
I'm sorry.
That your brief was basically directed at the argument that under Scott there was proof in the video, but you seem to be giving up on that.
I'm not giving up on the argument. I was concentrating on other matters.
Well,
right now.
okay, so
You want to?
I don't want to hear it. I mean, we all looked at the video. We don't see I don't see either how you could get anything out of the video that answers the question. But if you think so, you might tell us why.
Well, I think it does, but if you've watched the video, look, if you're having problems with the stop and the deliberate indifference, you're not going to find anything in the video that I can say right now that's going to change your mind today.
Well,
But-
the only thing then that you're saying the video does is it showed that he does stop and then he does proceed to the next place.
When I look at that video, what I see is he is initially compliant after the second stop, and then he attempts to stand up and rear back after the handcuffs are imposed, and that's what causes him to be
Maybe
taken
you had a
to the ground.
microscope and you could see that, but I couldn't see it.
All right, very well. I would like to mention, to follow up on something that I'm sorry, Judge Miller? Yes, the Judge Miller indicated about the qualified immunity, and that the two things that we're looking at was the law clearly established with that sufficient degree of certainty, and was the officer's mistake, if any, was it reasonable? And that's under White versus Pauley and Davis versus Scher. I don't believe there's any case law that would hold that an officer is not entitled to arrest for evading where someone stops, pulls over, and goes for 45 seconds if he subjectively wanted to go to his grandfather's house or had some other innocent explanation.
Even when the arrest, the warrant, all of that happened after he was stopped at his grandpa's house and after he got out of the car, and now the officers are giving him an arrest warrant for things that happened, you're saying that is enough?
Yes. Yes.
Take his idea of what happened. I mean, that's the problem.
I don't understand this notion of the evading was over once he stopped, because all evading is over once they're apprehended or they get away. So that I don't understand the court's concern about that.
Well, but he wasn't stopped because the police chased him or anything. He drove over there and he stopped.
Voluntarily stopped
He voluntarily stopped.
at his grandpa's place. That's his argument. I'm not saying it's true. I'm just saying I've taken his argument. He wasn't evading arrest. He just drove to his grandpa's house, got right out, did not attempt to resist arrest when he was being handcuffed. That's his argument.
But you look at this through the point of view of the reasonable officer on scene who's forced to make those split-second calls. You don't look at this based on the... By the way...
Is there any evidence in this record that they knew who he was? I mean, they had any prior contact with this person?
No, not that I'm aware of.
Yeah.
Not that I'm aware of.
I believe you were going to give us something about the hospital, and then where the evidence.
I did, but we get hung up here. So I think it is that same notion that there's no indication, there's no case law that says that they cannot rely.
But the question
on,
is,
You were gonna
where
give
is
us
there
some
evidence in the
evidence.
record?
I did say that, and I was caught up responding to this,
Okay.
so I would have to submit a letter after.
we can review the record.
Understood.
All right.
Thank you, Your Honor.
Mr. Davenport centers the defense on the clearly established prong of the qualified immunity doctrine, invoking White versus Pauley and Davis versus Scherer to assert that no controlling precedent placed the constitutional question beyond debate. Counsel contends that existing case law failed to put reasonable officers on clear notice that executing an arrest for evading violates the Fourth Amendment. Addressing the evidentiary record under Scott versus Harris, Mr. Davenport sought to rely on video footage to establish that Mr. Parham engaged in subtle physical resistance during the handcuffing process. However, the panel pushed back with significant skepticism. Judge Berzon emphasized that the video failed to blatantly disprove the plaintiff's account of non-resistance, while Judge Smith noted that the objective record demonstrates a voluntary stop followed by initial compliance rather than a continuous attempt to evade law enforcement. On June 8, 2026, the U.S. Supreme Court officially denied the officer's petition for a writ of certiorari. By declining to review the case, the Supreme Court left the Ninth Circuit's ruling intact, requiring the officers to face Mr. Parham's civil rights claims in federal district court. The civil trial proceedings remain ongoing, with no further updates at this time. This case presents fundamental questions about the limits of police authority and the scope of Fourth Amendment protections during routine traffic stops and subsequent arrests. Mr. Neal successfully challenged the officer's defense by asserting that their conduct failed to meet the threshold of objective reasonableness. Under the qualified immunity doctrine, an officer is shielded from liability unless their actions violate a clearly established constitutional right. Challenging this immunity is a vital mechanism for ensuring law enforcement accountability. Without it, individuals subjected to intermediate force force, unlawful searches, and denied medical care while attempting to safely comply would be left without legal recourse for their injuries. Even though the officers claimed they acted within the law, Mr. Parham was acquitted of all criminal charges by a jury, and the courts rejected the officers' attempt to dismiss the civil suit. By upholding the denial of qualified immunity, the United States Court of Appeals for the Ninth Circuit, and subsequently the Supreme Court, showed us that qualified immunity should not be an automatic shield given to officers in every interaction, but an exception reserved for rare occasions. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe to see more case analysis.